Good morning, everyone. Welcome and thank you for joining us for this almost festive edition of Breaking Ground. We're going to be speaking today about how a liability can be limited or excluded in a construction contract. And we're also going to touch on what the potential implications might be. Please do sort of forgive the awful pun you can see on your screens, but it's really worth being aware of these issues, given their potential for liability to be skyscraper high if the parties are not careful. We're going to move very swiftly on. So my name's Dan Korcz. I'm a principal associate in the insurance team here at Mills & Reeve. I mainly specialise in construction disputes. I'm joined today by my able colleagues, Kristyna Petrosjanova and Peter Lennon, both associates in the insurance team and who also specialise in providing advice to construction professionals and insurers. We're going to look first at some general rules surrounding contractual terms and when they can be enforceable. We're then going to look at some more construction-focused limitation clauses before going on to consider implications for insurance policy coverage. We'll look at some example wordings from a construction contract and some insurance policy wordings as well. Please note this session is being recorded, and as ever, whilst you can see us, we can't see you. So just first things first, what is a limited liability? Typically, parties to a construction contract have conflicting motives when agreeing limitations of liability. So on the one hand, the professional providing the services will want to limit its exposure to any claim arising out of its breach of that contract. On the other hand, the client receiving the services will want to maximize its ability to recover damages against the professional were it to breach the terms of that contract. Usually, parties tend to reach a compromise, and we often see scenarios where the professional's liability is limited to a multiple of its fee. So, for example, 5 times a fee of £5,000 would cap its liability at £25,000. Alternatively, and at the other end of the scale, a party might seek to limit its liability to the amount of its insurance cover. So, for example, an architect with professional indemnity insurance that has a limit of indemnity of 5 million might seek to limit its liability to that figure. There are some general rules, though, to consider on when a limitation of liability clause will be enforceable. So, Peter, can you tell us a bit more about how a party can validly limit its liability for negligence?
Yeah, of course. Thanks, Dan. If we can flick over to the next slide. There are 3 main common law routes to limiting liability, which you'll see on the slide there, plus a 4th that we'll come on to in a little bit. The first and probably most common is simply by incorporating a limitation or an exclusion clause directly into a contract. So in a construction context, you might see a clause in the company's standard terms of business, and I think we have an example of that later on. As you'll see from the slide, the other 2 common law routes are by disclaimer or by notice on entry to land. Those are much less likely to be relevant in the context of a construction contract, so we won't go into too much detail on those today. Also, just to be aware of number 4, it's also beyond the scope of today's talk, but there is some case law on the use of estoppel to limit liability, even without an explicit limitation clause in the contract. But for the purposes of today's talk, we're only going to be talking about number 1 on our slide. That's an explicit limitation or exclusion clause in a construction contract. If we can flick on to the next slide, please, Dan. So at common law, the requirements to have a valid limitation clause in a contract are fairly simple. The party seeking to rely on the clause needs to show that it was incorporated into a contract with the other party. If that contract wasn't signed, so for instance, if you have a situation where a contractor simply gives a homeowner a sheet of their standard terms, then they also need to show that the clause in the contract was fairly brought to their attention. Similarly, if the party who's trying to rely on the limitation clause has misrepresented the effect of it, even if they've misrepresented it innocently, that might make the clause invalid. And finally, it should go without saying, but the clause needs to actually cover the alleged negligent act, and that can actually be a surprisingly complicated issue once you get into the wording of the clause.
Yeah, so you mentioned there, Peter, the common law position. So does that mean there's a different position in legislation?
Yes, there are some limits in legislation which were essentially passed to stop limitation clauses from being abused. So the 2 main pieces of legislation to be aware of are the Unfair Contracts Terms Act, the UCTA, and the more recent Consumer Rights Act from 2015. So generally speaking, UCTA will apply to liabilities in the course of a business, and that's been clarified since the Consumer Rights Act was passed. UCTA only applies to non-consumer contracts, whereas the Consumer Rights Act applies, as the name might suggest, to contracts between a trader and a consumer. So a consumer in this case is an individual who's acting mainly for a non-business purpose. So to slightly simplify, UCTA would be the applicable act for most commercial projects and most business-to-business construction contracts. You might have situations where the Consumer Rights Act comes into play for construction claims relating to residential property. So, for example, you could have an individual employing an architect or a services engineer to carry out works on their home, and the Consumer Rights Act would be the proper act in that case. The key point is that both of the acts introduce a standard that the limitation clause has to meet in order to be valid and enforceable. So for non-consumer contracts, UCTA says the clause has to be a reasonable bargain for the parties to have agreed, bearing in mind a range of factors. If you have a consumer involved, the CRA introduces a slightly stricter test. So instead of being reasonable, the clause has to be fair to the consumer. Now, those acts are both probably a talk in and of themselves in the interpretation of what is reasonable and what is fair. But the key point to remember for limitation clauses is that even if the clause is properly incorporated into the contract, it needs to be reasonable in a non-consumer contract or fair in a consumer contract to be enforceable.
Okay, then. So does that mean that a party, an architect or a contractor or so on, can they completely exclude liability for their own wrongdoing as long as they meet these sort of tests?
In principle, yes, they can. You can imagine the courts are a bit more careful about totally excluding liability than simply putting a cap on it. But as long as the exclusion clause is reasonable, parties have the freedom to contract however they like, and that includes waiving any and all liability for negligence if that's what they want to do in their contract.
So a very classic lawyer phrase there, reasonable. In this context, though, how do the courts decide if the clause is going to be reasonable?
So specifically for a total exclusion clause, the starting point is a case from the 50s, Canada Lines and the King, a summary of which is up on the slide. That case has been approved repeatedly over the years, and the test in Canada Lines is, number one, if the clause expressly, clearly and unambiguously excludes liability for negligence, then that is the effect of the clause. What that means in English is if it's obvious that the clause intended to exclude negligence, the court won't try and change what the contract says. However, if the wording of the clause is ambiguous, the court should consider whether the words are wide enough to exclude liability for negligence. And if the words are wide enough, then the court has to next consider whether there's any other head of damage that the defendant might have been trying to exclude instead. If there was, the court will assume the defendant was trying to exclude that other head of loss instead of negligence. So the key takeaway there is that if a clause totally excludes liability, as opposed to just placing a cap on it, it needs to be clear and unambiguous. If there's any doubt at all about whether that clause was intended to exclude negligence, the court will usually interpret that against the party trying to enforce it.
Thanks, Peter. So now we've sort of covered the general rules on when limitation clauses could be enforceable. Kristyna, what kind of limitation clauses could we expect to find in construction contracts?
Thanks, Dan. On the slide, you'll see the four main categories of limitation clauses. Next slide, please. As you briefly mentioned earlier, caps on liability are often either a percentage of the professional's fee or by reference to the limit of indemnity under the professional's PI policy. In the latter case, the appointment will usually require the appointment to maintain both the prescribed level of cover throughout the duration of the appointment and for a fixed number of years afterwards. Secondly, you can have restrictions on limitation periods. The limitation period for bringing claims under a professional appointment is normally determined by reference to the Limitation Act 1980. However, there is nothing stopping parties agreeing to a different period. Therefore, clauses which supersede the Act are not uncommon in appointments for construction professionals. For example, on the slide, we have the wording for REBA's Standard Professional Services Contract. A clause can also exclude certain types of losses. On the screen, you'll see some common examples. Indirect and consequential losses are generally those which are not the natural results of the breach, but arise from a special circumstance. Losses which might fall under the last example on the screen are those arising from pollution, contamination, or asbestos. Lastly, net contribution clauses. NCCs govern a situation where two or more parties, for example, an architect and a contractor, have joint and several liability for the same loss or damage. The effect of an NCC means that, in that situation, each party's liability will be limited to the amount that would be apportioned to that party by a court. So, if a court were to determine that the architect was 30% responsible for the loss claimed and the contractor 70%, then the architect's liability will be limited to 30%.
Okay, so what would then happen in sort of a circumstance where you didn't have a net contribution clause then?
Well, the principle of joint and several liability means that the employer could recover 100% of its damages from the architect. It would then be up to the architect to pursue a recovery claim against the contractor for its contribution. You can see why NCCs are fairly common in construction professional appointments.
Thanks, Kristyna. So sort of see how this might look in practice. I've put an example wording on the slide. So in clause 1, we can see that the professional has limited its liability generally for any claims arising from consequential loss. For example, if a claimant was seeking to rectify a defective facade of a building and also sought damages in respect of an ongoing waking watch, the costs of the waking watch are consequential and arguably not recoverable under this clause. In clause 2, we can see that the professional has capped its liability at the lower amount of either A, a percentage of its fees paid by the client that year, or B, £10,000. So in both of these sort of scenarios, the client's ability to make a claim in damages from the professional is quite severely limited. Thinking also then about coverage impacts, because I'm aware we have quite a few insurers on this call. Kristyna, what might happen then in a scenario where an insured told its insurers that it always limited its liability, but in fact that was not the case? What sort of consequences could there be?
Well, this can amount to a misrepresentation. As we all know, prior to policy inception or renewal, an insured is under a duty to make a fair presentation of the risk to insurers. Many of you will be all too familiar with Section 3.3 of the Insurance Act 2015, which outlines the duty. The key part for our example is subsection C, set out on the slide. Every material representation as to a matter of fact must be substantially correct, and every material representation as to a matter of expectation or belief must be made in good faith. Often, proposal forms will ask how the insured deals with limiting and excluding their liability in their contracts with third parties. When answering these questions, insureds will need to make sure that all responses, which would amount to representations, are substantially correct. Where these representations turn out not to be true, then the insured may have breached its duty of fair presentation.
Okay, so if the insured has breached its duty, what could happen then?
Firstly, insurers must determine whether the breach was deliberate or reckless. If they conclude that it was either of those, then they can avoid the policy, refuse to pay all claims, and do not have to return the premium paid. However, if they conclude that the breach wasn't either deliberate or reckless, then the breach will be innocent. In the case of an innocent breach, the remedy available to an insurer will depend on what they would have done had they been provided with a fair presentation. We have set out on the slide sliding scale of options available to insurers according to the Act. In summary, if they would have charged a higher premium, then they're entitled to apply a proportionate reduction to the amount to be paid on the claim. If they would have imposed different terms, then they can apply those terms. If, however, they would have not entered into the policy on any terms, then they can avoid the policy, refuse to pay all claims, but must return the premium paid.
So you mentioned two sort of scenarios there, a deliberate and a reckless breach. If we just sort of focus on reckless, and I appreciate that's another rather classic legal phrase, but in this sort of scenario, how can a breach be reckless?
Of course. Well, an insured will have acted recklessly if it did not care whether or not it was in breach of the duty. And this is intended to indicate a greater degree of culpability than acting carelessly. There is, however, a presumption that a breach is innocent, and insurers will need to have sufficient evidence to prove that a breach was either reckless or deliberate.
Thanks, Kristyna. I think another point to flag to both insurers and insureds if they're on this call is that in some insurance policies, there are specified exclusions for consequential loss, along with costs of rehousing. So, for example, quite relevant where you've got buildings which are being remediated and the residents moved out. So for effective insureds, it's going to be quite vital to try and not to to at least try and exclude any liability for consequential losses, particularly when waking watch and rehousing costs can be in the hundreds of thousands of pounds on large-scale refurbishments, and that might be something their policy doesn't cover them for. So just moving on now, Pete, you obviously deal with subcontractors quite a bit. Is there anything else that we need to be aware of in these types of claims?
Yeah, I would say in a subcontract or a multi-party arrangement, privity of contract is probably one of the basics to be aware of. We've put some notes up on the slide there. Ordinarily, privity of contract is a legal principle. That means if A and B have agreed contract, and let's say that contract includes a limitation or an exclusion clause for liability for negligence, then a third party, C, can't enforce the terms of that contract. It's a bit easier to see visually, hence the slide. Let's say A is the client for a particular construction project, B is the main contractor, and C is a subcontractor employed by B to carry out part of the works. What privity of contract means ordinarily is that if A sues C for negligence in their part of the works, with privity of contract, C wouldn't usually be able to rely on the fact that B has an exclusion clause protecting them against A. However, there are some ways around this, and the first place to look at potentially getting around it as a subcontractor or their insurer is the Third Parties Act. So under the Third Parties Act, C could enforce the exclusion clause in A and B's contract if either the contract expressly provides that they can enforce it, or if a proper construction of the contract suggests that the term was intended to confer a benefit on C. To fit under either of those definitions, the third party needs to be expressly identified in the contract. That could be by name, or that could be by description of a category. So, for instance, B's agents and subcontractors could be a description of a category covering C. And that proper construction point contract is also why, if you look at a lot of commercial contracts, you often see clauses explicitly saying they don't intend to confer any benefits on anyone who isn't a party, or even more explicitly excluding any reliance under the Third Parties Act, so that everyone involved is sure as to what they're contracting to and what they're able to rely on. There's one other very small oddity to note. So when I talked a little bit earlier about UCTA, I mentioned that UCTA normally restricts A and B to relying on a limitation clause in a contract if that clause is reasonable. The Third Parties Act actually explicitly says that if, in this situation, C is trying to make a claim based on breach of the contract, UCTA doesn't apply. So what that would mean in practice is if C sues B for not complying with some term of the contract, and that's claimed to be negligence, if B has an exclusion clause, that clause doesn't need to pass the UCTA test of being reasonable, meaning it's more likely to be enforceable against C than it would have been against A, who was the original party it was intended to protect against. So just a little bit of an oddity in the interaction between UCTA and the Third Parties Act there.
Thanks, Peter. Yes, so I appreciate this is a very busy time of year for everyone. So that's all we have time for today. Hopefully we've taken up as little time for everyone as we can. Thank you all for joining us. As always, when we sort of finish now, there's going to be a feedback form on your screens when we sign off. Feel free to include there any topics you'd like to consider us speaking about in the future. We always like your feedback. We've got thick skins, we can take it. And remember, if you want us to provide any more detailed answers on anything that we've covered this morning, breaking ground is always meant to be a fairly quick run through, but we're more than happy to speak to you in detail on any of these points. So just get in contact with us directly, phone or email, etc. In the new year, we're going to be joined by my colleagues Neil Davies, Tim Russell and Nathan Jones, and they're going to be discussing the recent case of Lend-Lease and ACOM. So it's a useful refresher on limitation periods, I'm told, and the scope of a professional's duty of care. So particularly relevant, hopefully, for those of you dealing with design and build contracts. Hopefully you're able to join us on that occasion, but from all of us here, we wish you a very good rest of the day, very happy Christmas, and hopefully a big long break from anything construction and building safety act related. Thank you, everyone.